Kevin Stenger, Stenger.
You may proceed.
Thank you. Sir, you are employed as a computer forensic examiner for the Orange County Sheriff, correct?
I am.
Right, and you have testified as an expert witness in this trial on 2 occasions now,
Yes, ma'am.
correct? All right. On those prior occasions, you testified about about a portion of the internet history that was in deleted files on the HP that was seized from the Anthony home, correct?
I did.
And when you testified, you talked about specific dates of March 17th and March 21st.
Yes,
Is that
ma'am.
correct? The deleted Firefox history, however, spans a broader range of time, does it not?
It does.
Can you tell the jury the range of time that the deleted internet history that you carved out of the hard drive encompasses?
It starts on March 4th and goes through March 21st.
Now, you testified that there were various forensic tools that you utilized to perform an analysis on certain words contained within that history, correct?
Yes, ma'am.
If I may show the witness what has been marked as states SB for identification.
You may.
Do you recognize what I showed you?
Yes, ma'am.
What do you recognize it to be?
That is a disk that I created with 2 different report files on it.
Okay. What report files are on there?
Report from net analysis and a report from cashback.
Right. And aside from the filtered report, which dealt exclusively with the 17th and the 21st, does this report deal with the entire deleted history?
It does.
Your Honor, at this point, I would seek to introduce SB for identification into evidence.
What says the defense?
We would have no objection to conditional admission until we've had an opportunity to review it. May I speak to Ms. Drainberg?
Yeah, you may.
Your Honor, I think we have a stipulation as to a conditional admission of the evidence.
The witness is going to be testifying about documents contained on there, as I've indicated to counsel.
Are you offering it in unconditional or without conditions?
Well, my offering it was without condition because I believe the witness has identified accurately the documents contained on.
Mr. Baez, what is the defect in the predicate?
Unfortunately, I think it requires a little explanation, Your Honor.
Objection over will be received in evidence.
I can lay.
Yes, sir, you may. You may proceed.
Thank you. Investigator Stenger, were you asked to conduct keyword searches utilizing the information contained in that deleted internet history?
I was.
And what keyword searches were you asked to perform?
I was asked to examine those files for anything related to chlorophyll, to neck, hand sanitizer, bamboo, and Gentiva.
Can you explain to the members of the jury briefly how a keyword search would be performed on either the net analysis or the cashback report?
The net analysis report is essentially a spreadsheet, and it opens up in Microsoft Excel. In order to search the records in it, you simply use Excel's search function to open up and search and then look for whatever word it is that you're looking at. The cashback report is a HTML-based report. And when you open it up in Internet Explorer, Internet Explorer has a search feature built into it that allows you to search for these different words as well.
All right. Would it assist in your testimony to be able to see, we could start with the net analysis report and show the jury just how the keyword search is done?
It would.
Your Honor, may we have permission to publish the last part? Yes, I did offer SB for identification into
Does
evidence.
the defense wish to voir
No, sir. Based on the previous representations, the defense has no objections.
be received in evidence as states numbered?
346.
And may we publish the report to the jury at this point
You
during the
may.
witness's testimony? Now, you had indicated that at least one of the reports is a Excel-based report. Is that the one that we're looking at?
You're currently looking at the net analysis report that's opened up in Microsoft Excel.
Okay. And how is it that the keyword search is most easily done in this report?
You can actually use a shortcut key. Control F will actually bring up the search function.
All right, I had asked Mr. Perez to hit Control F. Is that the search function that you had anticipated appearing?
Yes, ma'am.
Okay, and once that search function appears, what would the next step be to perform the keyword search?
We can enter whatever keyword is desired into this search, and then we can search the entire spreadsheet at once or one at a time.
Right. Now, you indicated that you were asked to search for chloroform.
Yes, ma'am.
I'm sorry, chlorophyll.
Chlorophyll.
Chlorophyll. Now, that obviously can be spelled many different ways. How do you compensate for that?
If we use only the very first part of the word, the very first 4 or 5 letters, we can search for any version of the spelling, whether it's spelled with a P-H-I-L, P-H-Y-L, or P-H-Y-L-L. We'll still get anything that starts with the first 5 letters.
All right, so if I ask Mr. Perez to put C-H-L-O-R into the search, does he hit find next?
We will get the very first instance where those are the first 5 letters.
All right, is that the box here that has appeared on this superimposed over the report itself?
Yes, this is a very large, it's called a URL, Uniform Resource Locator. That is the address bar that you see at the top of Internet Explorer or any of the other internet browsers. And it's so long that it actually appears as several lines at the top of the screen.
All right. Now, does this reveal a chlorophyll search?
Now, this is actually a URL that has a reference to a chloroform habit webpage.
All right, is that,
Like to approach briefly?
You may.
proceed?
You may proceed.
Thank you. Using the CHLOR, it pulls up chloroform as well as chlorophyll were a version of chlorophyll to appear in this search history, correct?
Any word which contains CHLOR would appear in this type of search.
Okay. Did you find, doing this keyword search, any references to chlorophyll, however you want to spell it?
No, ma'am, we did not.
Okay. Would the same be true if the keyword search was performed in the other report, the cashback report that you had mentioned?
It would.
Now, you mentioned that you were asked to look for hand sanitizer.
I was.
Okay. Do the words hand or sanitizer or in conjunction with each other, appear at any point doing a keyword search of this deleted internet history?
The only thing I searched for in these two is the word sanitizer, and sanitizer does not appear in any of these documents.
You indicated that you searched for the word neck. If we can close that out.
Same issue.
Overrule.
If we could close out that and do another search. Is that the result of the search for neck?
Yes, ma'am.
Okay. And that is in conjunction or in connection with this neck break.
There is this one, and I believe there's one other search in there. This is just a title. There is an actual search in there
Right.
also with a neck.
All right, can we hit find next? Is this the other search that you are referring to?
Yes, ma'am, it is.
All right, and these are the instances of neck in conjunction with other terms.
Yes, ma'am.
Can you tell from this URL if this was a pop-up of some sort that occurred during this internet history?
Response.
I believe Mrs. Anthony testified that during her searches, there was a pop-up.
Objection overruled.
This is a Google search that is specific to the words neck and breaking.
How can you tell that?
It said the URL starts out with google.com search, and then anything that the user types into the Google search box will appear after the Q equals sign that's on the screen. And the words that will appear afterwards are what the user typed in. And then as soon as they hit the search box, this actually appears in the top of your internet browser. In this instance, it would have been neck and a space and breaking. This is not the result of a pop-up, but is the result of a human being specifically entering neck and breaking into the Google search box and pressing search.
We can close that out. I'm getting some feedback. When you searched for chlorophyll, you said there were no hits during the keyword searches.
That is correct.
Would that mean that there was no search for chlorophyll in conjunction with any of the chloroform-related entries?
That is correct.
You said that you were also asked to search for bamboo.
Yes, ma'am.
Okay. Did you find any instances of bamboo appearing in this deleted internet file during a keyword search?
None.
None?
Not at all.
Were you asked to determine whether or not there was any access to a Gentiva website?
I was.
How did you determine whether or not any access to a Gentiva website occurred during this deleted internet history?
I searched for gentiva.com, which was part of the address of their website.
And what were your findings?
There is no reference to gentiva.com in this history.
Now, aside from the two reports that you've been talking about, did you utilize any other forensic tools in an effort to confirm these findings with the keyword search?
I did.
Can you tell the jury what you did to confirm that?
In an effort to make sure that none of these terms appeared anywhere in this file, I utilized a tool which breaks down the raw internet history file into records. And it then creates a text file out of that. I searched that text file for these terms and found no reference to them. Then the MORC database is essentially a text file. There are parts to it which are not readable. However, the vast majority of it is text. So I simply imported it into Microsoft Word and then used Microsoft Word's search feature to see if I could find any of these terms, and could not. Then I took the raw file itself and imported it into two forensic programs, one called FTK and another one called InCase. And I repeated the searches with both of those forensic programs and could find nothing. Then repeated it one more time with a very old tool called a hex editor. And I examined this file using a hex editor that displays the information as both text and in what is called hexadecimal, base 16 format. And I searched that file that way for these terms and could find no references to them.
Did you find in this history some reference to anything to do with dogs?
I do believe there was one date where somebody searched for fleas.
How to get rid of fleas?
Yes, ma'am.
Thank you. Sir, I have no other questions, Your Honor.
Cross-examination?
Good afternoon, Sergeant Singer.
Sir,
What is yahoo.com?
yahoo.com?
Yeah.
It is a domain, sir.
Okay, if I go to yahoo.com, what comes up?
The web page for Yahoo.
Okay, and what's on that page?
That would be a number of different things depending on what Yahoo has on that page that day.
I could find out the news.
That is correct.
I could get a map if I want to go to the local drugstore.
That is correct.
I could find out what's going on in the stock market.
Yes, sir.
I could find out my horoscope.
Yes, sir.
I could find out what Paris Hilton's doing today.
Possible.
Okay. So yahoo.com doesn't tell me much about what's going on that page, does it?
No, sir.
In fact, Yahoo's maybe not really a word. Depends, I guess, what part of the country you're from, right?
Yes, sir.
Okay. Now, this file that you have is of web addresses, correct?
Yes, sir.
Okay. So all you were searching for were the domain names or the web addresses, kind of like a yahoo.com.
With the exception of the Google search pages, which contain information entered by the user themselves.
But absent that, all you were looking at were the domain addresses of what was on this file for 1 month. Less than a month, actually.
Yes, sir.
And unless the website had bamboo on it or chlorophyll in the domain name, you wouldn't have gotten a hit.
That is correct.
And this neck breaking thing, you're aware nobody's neck was broken in this case.
I believe your statement is correct.
That has nothing to do with this case.
Objection, Your Honor, to counsel's statement of opinion.
Now, you were only given this information. Oh, actually, let me go back to the neck breaking. Can you bring that? After the Google search of net breaking, the very next website that's visited is fightingarts.com. Isn't that correct?
That is one of the entries, yes.
Okay. And that's a kung fu website?
URL would indicate that it has something to do with martial arts.
Okay. And that was visited how long after the search? That would have been what came up as a result, right?
That would have come up on the search page, and then the user would have clicked a link on that web page to go to that site.
So that search, whoever did the search, ended up looking up a self-defense website.
If we assume that fighting arts is a martial arts website, that would be correct.
And then again, as you just qualified your answer, you can't say what's on that web page unless you actually visit it. And that's why you qualified your answer.
Yes, sir.
Okay. Now, you weren't asked to do this stuff back in July of 2009 when Mrs. Anthony gave her deposition, were you?
No, sir.
In fact, you were just contacted recently after Mrs. Anthony testified and the state wanted to impeach her.
Yes, sir.
Now, Mrs. Anthony also testified to looking up alcohol and peroxide. Did you do searches for those?
No, sir.
No?
I did not do specific searches for them. I know they exist.
You know they exist on this file,
Yes, sir.
and you've seen them.
Yes, sir.
Okay. So that's why you didn't have to look for them, correct?
Excuse me? Can you-
And that's why you didn't have to look for them.
that is correct.
Thank you, sir.
May the witness be excused. Thank you, Sergeant Stinger.
I'm Sandra Osborne, SANDRA-OSBORNE.
You may proceed.
Thank you, ma'am. You are a forensic computer examiner with the Orange County Sheriff's Office that's testified at least twice in this case, correct?
Yes, ma'am.
Were you asked to search the entire hard drive of the Anthony family's HP computer for certain keywords?
Yes, I was.
How was that search performed? Before we get to the actual words, how is that search performed?
With the computer software that I'm using to conduct my forensic exams, I can put certain keywords in, any keyword I want, and ask the software to search the entire hard drive for the characters that make up that word, and it will report back to me.
All right. What software did you utilize?
NCASE forensic software?
Okay. And you testified about the NCASE program before?
Yes.
Okay. And that is a forensic application that is widely accepted in your discipline, correct?
That's correct.
Okay. What search terms were you asked to identify or to see if they appeared anywhere on the hard drive of the Anthony's home computer?
I was initially asked to search for chlorophyll, hand sanitizer, and bamboo.
Right. Now, chlorophyll can be spelled a variety of ways. What did you do to ensure that any spelling deviation was compensated for?
I searched the entire hard drive for the first 5 or 6 letters that encompass chloro, CHLORO.
How long does that search take?
On that hard drive, it took several hours. I let it run all day and then overnight.
Did you find any spelling of the word chlorophyll anywhere on that hard drive?
In one place I found it, and it was in a Microsoft dictionary, which comes with the installed software when you install a Microsoft operating system, and that's the only place.
Now, you said that you were asked to search for the term hand sanitizer to see if it appeared anywhere on the hard drive of the Anthony's computer, correct?
Correct.
Does it?
I did not find it. No, it doesn't.
You said you were asked to search for the word bamboo. Did you find references to bamboo aside from dictionary references at all?
Yes, I did.
Okay. What did you find?
bamboo figurines, bamboo lanterns, bamboo furniture, bamboo flooring, references in gaming computers, reference to bamboo stakes. That was pretty much it. Furniture, figurines, household products contained bamboo.
All right. What type of household products did you find?
The furniture, bamboo, floor surfacing, jewelry boxes, fences, cookware, lamp lights, basins, rugs, bamboo panda bears, and tiki bars.
Did you find any reference to bamboo leaves as a poisonous substance?
No.
Were you also asked to determine whether or not there were any any indicators of access to the Gentiva website?
I was, yes.
Right. How did you accomplish that?
I was given 3 specific login names to the Gentiva website for remote login, and I did the search for those 3 terms.
Okay. And were you able to find anywhere on the hard drive evidence of any remote login to Gentiva?
No, I was not.
Right. Thank you. I have no other questions, Your Honor.
Cross-examination.
Good afternoon, Ms. Osborne.
Sir.
When someone deletes something from their computer, it goes into the unallocated space, correct?
Correct.
Now, and then when something is deleted again, it overwrites the certain space. It doesn't fall into order, does it?
It can, but not normally.
Okay. And to explain this, I know you and I know what we're talking about, but I want to kind of break it down a little bit better for the jury. Basically, something gets deleted and it goes somewhere else in the computer, correct? Somewhere on the hard drive.
No, the data of the content of the file, it stays where it is. It stays in the exact location where it is.
Okay. And then when something is deleted, sometimes it will take away what's there in the unallocated space and overwrite it, correct?
When a file is stored on a computer and then the file is deleted, a user deletes the file, the reference to that file is made available is deleted, and it makes reference to the file system where that data resides on the hard drive. The reference to the file itself that was residing on that hard drive is told that space is now available. The data still resides there until a new file is placed in that space. And that will overwrite, however big that file is, will overwrite the original file that was there.
So to put it in English, when you delete things, they do at times get deleted and they're no longer available on the hard drive.
They get overwritten, yes, sir.
They get overwritten and you can never recover it again.
That's correct.
Okay. And it's not done in order. The computer pretty much decides where to place it.
The file system that's installed on the computer has control over the management of the files.
Okay. And the entire hard drive, you never know what has been deleted because of that specific purpose.
It's hard to tell what's been overwritten because the new data is now occupying that space, but otherwise data is available that has been deleted.
Okay. Thank you.
Oh, I can add this.
You may. You all right?
Just briefly, is this why sometimes in unallocated space you will have fragments of a chat or something else?
That's correct.
Right. And when that happens, when there's been something that's been partially overwritten, that's quite obvious to you because it's fragmented.
That's correct.
Thank you, Your Honor.
May the witness be excused.
Yes.
Thank you.
Thank you, Judge.
My name is Yuri Melish, Yuri-Melich.
You may proceed.
Your Honor, may I approach the witness with the documents that were
You may.
introduced? Your Honor, I believe that I moved to introduce those items at the time that I handed them to the clerk without objection, if we could get numbers for them.
We have no objection, Judge.
They will be received in evidence as states numbered.
SC will become State's Exhibit number 347. SD will become State's Exhibit number 348. And SE will become State's Exhibit number 349.
You may.
Detective Mellett?
Thank you.
347 in evidence. Do you recognize that document?
I do.
What do you recognize it to be?
The home phone records for Mr. and Mrs. Anthony on Hope Spring.
Are these items among those that you testified to earlier that you had subpoenaed in connection with this case?
Yes.
Okay, what was the home phone number in June of 2008 for the Anthony landline?
407-275-4909.
I'll be showing you 348 in evidence.
Thank you.
Do you recognize that?
I do.
What do you recognize that to be?
The cell phone records for, I believe this one is George Anthony.
And what was the cell phone number?
407-403-3564.
Are those from the period of time from June through July of 2008?
Yes.
And finally, I'll show you 349.
Thank you.
Do you recognize those?
Yes.
What do you recognize those to be?
These are the cell phone records for Cindy Anthony
For what period of time?
for June 1st into July of 2008.
And what was the phone number that she was utilizing at that time?
407-808-4731.
Okay. Did you examine those documents to determine whether or not there were any calls from the Anthony home to George Anthony's cell phone during the week of June 16th of 2008?
Yes.
Were there?
No.
Did you determine whether or not there were any calls between Cindy Anthony's assigned cell phone to George Anthony's phone the week of June 16th of 2008?
No, not for that week.
You determined there were or were not any calls for
There
that
were
week?
not. There were not.
Okay. That's all the questions I had, Your Honor. Thank you.
Cross-examination.
Sir, you know that that cell phone is not the only cell phone that George Anthony had, don't you, sir?
No, I do not.
You've never been made aware by Cindy Anthony that George had multiple cell phones.
No, not that I can recall.
You've never been made aware of by George Anthony that he had multiple cell phones.
Objection, hearsay.
Oral.
Not that I can recall.
You've never been made aware of by Crystal Holloway that George had multiple cell phones.
Not that I can recall.
Hearsay.
Overruled.
May I approach the witness, Your Honor?
You may.
I'd like to show you a statement given to you from George Anthony on July 24th, 2008, and direct your attention to page 36. Can you please read lines 20 through 21?
This is George Anthony.
Sustained.
Read it to yourself, sir. Is George Anthony there telling you he has a company cell phone?
Sustained.
Does that refresh your recollection as to whether George Anthony ever told you he had a company cell phone?
Question, Mr. Baez.
Just refresh the recollection of the witness, Your Honor.
Here, hearsay, Mr. Baez.
Did you ever pull the records of any company cell phones for George Anthony, sir?
I didn't recall him giving me numbers for a company cell phone.
My question to you, sir, is did you ever pull George Anthony's work cell phone?
Again, not recalling that he had a work cell phone, so the answer would be no.
Do you recall now that he had a work cell phone?
After reading that,
No, can't do that. Next question.
Do you recall if Crystal Holloway ever informed you that he had multiple phones?
Hearsay.
Sustained.
If I can have just a moment, Judge.
Any witness be excused?
Actually, I do. I'm sorry. Sir, were you ever aware that all of the Anthonys had boost phones at any given time?
Objection, vague time frame.
Sustained.
During the months of, well, any time during 2008, were you made aware that the entire Anthonys had boost cell phones?
Objection, hearsay, and the time frame alleged here is June of 2008.
Sustained as the time frame. May the detective be excused?
You may.
Thank you, detective.
thank you, sir. Thank you.
Any more witnesses?
Your Honor, the state has no further rebuttal to present.
State recognized president of jury.
Your Honor.
Defense.
Yes, sir, we do.
Ladies and gentlemen of the jury, this concludes the presentation of all evidence. We will convene on Sunday at 9 a.m. for closing arguments and instruction on the law in this case. Please remember all of my previous admonitions. Any additional instructions on behalf of the state
State Your Honor.
or the defense?
Nothing from the defense.
Members of the jury, you may be excused. Okay, you may be seated. Mr. Mason?
Your Honor, at this time, the defendant wishes to renew the several previously made motions. One, the motions that we have made for mistrial, particularly, and not waiving any, but particularly the one regarding the introduction over objection of the video superimposition of photos predicated with Dr. Warren. You know exactly.
Yes.
Okay. Renewing the motion for mistrial on that. I also,
Renewed motion for mistrial will be denied.
I also wish to raise again for your consideration the most recent motion we did, the ring motion, which you have Ms. Fennell argued challenging the constitutionality of the death penalty in light of last week's decision from the federal court in the Southern District of Florida.
You want me to continue to reserve ruling on that, Mr. Mason?
I do.
Huh?
I want you to continue on that, indeed, to reserve. I'm just making sure that the record's clear. We're not waiving or abandoning anything.
Okay.
All right. And with respect to the judgment of acquittal, I'll renew on all grounds previously argued, and I'll add in addition to that. As a result, at the close of all of the evidence, there is at least as valid a reasonable inference of a death by accident or circumstantial evidence of other cause of death, as there is this mythical fantasy from the prosecution that this child died as a result of either chloroform poisoning, depending on what week of trial we're in, or smothering or suffocation by duct tape, all of which is fantasy, all of which is inference, and at least there's as much inference now the record evidence of a drowning. We have established that the child had the ability to go in and out of the house, up the ladder, in the pool, and with the rest of the evidence presented, we think that there is sufficient grounds for you to grant a judgment of acquittal. There has yet to be any evidence in this case as to how this child died, which is the state's burden, not ours, where she died, which is the state's burden, not ours, when she died, same burden, and who may have been in attendance with her or not. Those questions have not been answered since July the 15th of 2008. And I think at that point, the court must conclude that a jury must necessarily have a reasonable doubt as to these essential elements of the charges. There is no issue, no evidence of premeditation, unless you buy fantasy on fantasy or legally stacking inferences on inferences. There is no evidence of a felony murder, unless you suggest that there is some form of aggravated child abuse, which requires, by most recent case law, evidence of torture, intent to torture or maliciously harm. No evidence of that whatsoever. And so if you look the jury instructions that we're about to all agree on and go through those elements, the elements as to counts 1, 2, and 3 have not been proven. What they have proven is that the defendant, Caylee Anthony, told many falsehoods to friends and family for various reasons. That the child is dead. And let's see, what else? Oh, they proved that she was a very good, devoted, and loving mother for every witness that took to stand in that regard. So all of the 366, if that's the right number, documents of evidence in here show a myriad of things to talk about. Was there chloroform used or not used? Well, all the experts say no, there may have been chloroform in the trunk of the car. So what? Decomposition or other. So what? There may be, there was duct tape found near the body and or maybe adhered to part of the hair mass on the right side of the skull when found. No DNA to link it to anybody, excluding, in fact, the DNA excludes that it was the defendant. It excludes that entirely. There's no evidence that the duct tape was placed on this child's face at all, and if so, prior to death. There's no evidence that the child died from any chloroform poisoning. That's just all been a media hype for 3 years. And I urge you, in considering these things, think about this. Without going all the Fry hearing stuff, that'll make good reading for somebody someday. The fact of the matter is that Dr. Sigmund took the air from the trunk of the car, got 2 Toddler bags, sent one to Dr. Voss, and took one to himself. And his primary ingredient was gasoline with a trace of chloroform. And Body Farm Dr. Voss, chemist Dr. Wise, said that the biggest spike they had was chloroform, but no quantitative analysis. So the whole thing is just a bunch of confusion. Was there a chloroform in the trunk? Maybe. In amount, no different from the atmosphere. Was there evidence that the child was killed by it? No. Is there speculation? Yes. So if you separate the facts from fiction and inferences being stacked on inferences, this is really not something that should result in guessing by a jury. They shouldn't be burdened to have to guess something like this. You can take the burden. You're used to it. That's your job. And your burden, I suggest respectfully, is to say you're right. This does require inference on inference, guessing, speculation, but there is no proof as to when, who, and how the child died. And I urge you to enter a judgment of acquittal as to counts 1, 2, and 3.
Thank you, Mr. Mason. State response?
Just briefly, Your Honor, Mr. Mason is arguing factual matters that are more properly resolved by a jury, and it is our position that the jury should be the body that makes the decision as to what is indeed fact and what is fiction. As a legal matter, as argued at the close of the state's evidence, there is sufficient evidence to go to the jury on each of the charges as charged, and we would urge the court to deny the judgment of acquittal on that basis. The defense during their case having presented no new hypothesis of innocence.
Anything else, Mr. Mason? Renewed motion for judgment of acquittal will be denied. Okay, what time do y'all want to meet on Sunday?
30 to finalize jury instructions. That'll be fine. We'll have a telephone conference at noon tomorrow. Good for everybody?
After you get up?
Does that mean I can sleep till 11:55? That's pretty good.
We'll get the card as best we can work out amongst ourselves with your standards and aspire to sparing all the ones out there.
Mr. Mason, you need to turn on the microphone.
This one, right?
Go ahead.
We're going to be able, I think, to work out just about all that we will need your intervention as to the theory of defense instruction, and maybe one special. Mr. Ashton indicated he was writing, going to do some special, but the rest of it, I am certain we will go through the myriad of standards. We've been working on that. I'm sure that the same is yours.
Based on Arizona versus Shad and that concept, and I'll send it to you first thing tomorrow morning around 10. I guess that's not really first thing, but and we can discuss it at noon.
Do y'all remember the murder of Judge Chillingsworth?
Yes, I do.
Did they ever?
Absolutely.
Huh? Did they ever find his body?
Fishing trip.
Did they ever find his body, Mr. Mason?
No, they never found his body, but they found blood all in the back of the boat. Now, this is going back a long time. This is back in the 70s. And
He
they
went
had
fishing
witnesses
and
of him
didn't come
going
back.
out fishing and not coming back.
Travesty.
Okay. All right, court will be in recess.